welcome to my class. Today we are going to see the topic on high seas. So we all know the ocean or the seas are divided into various zones like territorial sea, internal waters, contiguous zones, exclusive economic zones, and then high seas. So today we will be looking at what are high seas and what are the important concepts that you have to understand from high seas. So initially high seas or res communis. When I say res communis, it means that high seas are for all. It is for all. So it is a kind of res communis. So res communis means it belongs to all. It belongs to all. Common heritage of mankind. Common heritage of mankind. Next, this principle that it belongs to all is subject to recognition, acquiescence, and prescription. So what is recognition, acquiescence, prescription? It means that in case if any particular country has done any activities that shows that it is exclusively to them, then the principle of res communis will not apply. Let me explain to you like this. Say for instance, a country like Iceland. Usually the high seas are for all. Now, if Iceland delineates or delimits some part of high sea as its own territorial sea or contiguous zone because of its special characteristics, because of the resources that is available to that place, and if any country is silent to that or it is recognizing that practice, that if any of the high seas has been reserved for a particular country, if a country reserves a particular part of high seas for it, and if any country which is not objecting to it or recognize that or accepting its position, then that particular part of the high sea will belong to the particular state which says that this part of high sea belongs to me. And when they say that this part of high sea belongs to me, any state which feels that that position is unacceptable, it must have shown its objection at that point of time. If it is not objecting and if it is agreeing, or if it is recognizing it, or if it is agreeing to that fact, or if it is keeping silent, then that particular part of high seas can go to any state. But usually high seas belongs to everybody. Now let us see some of the articles, article 86 and 87 of UNCLOS. So what is 86 and 87 of UNCLOS talk about? So 86 of UNCLOS talks about the definition of high seas. So according to article 86, the provision of this part, that means high seas, apply to all parts of the seas that are not included in exclusive economic zone in the territorial sea or internal waters of a state, which means that the high seas are defined in the manner in which any part of the ocean or seas which is not defined as exclusive economic zone or territorial sea or internal waters of a state, then it would be called as high seas. Next, article 87 talks about freedom of high seas. So some of the important freedom of high seas are the freedom of navigation, freedom of overflight, and the freedom to lay submarine cables and pipelines subject to part 6, freedom to construct artificial island and other installations permitted under international law, freedom of fishing and freedom of scientific research. So, first we saw the definition of the high seas, which says that any part that any part of the sea which is not an exclusive economic zone or a territorial waters or internal waters or high seas. Next, some of the freedoms that are in high seas include scientific research, freedom of navigation, freedom of overflight, freedom to lay submarine cables and pipelines, freedom to construct artificial islands, and freedom of fishing, and subject to conditions laid down in section 2. So, there are certain certain conditions in sections 2 with regard to fishing, but so far according to UNCLOS, the high seas, the resources in high seas is generally available to all as long as it is not being claimed by any state which has been acquiesced or recognized by any other state. And the next important thing is high seas shall be reserved for peaceful purposes. So, you do any activities like nuclear testing or weapons of mass destruction testing in high seas, then that is violative of UNCLOS III, United Nations Convention on Laws of Seas, 1982. Next important thing with high seas is that jurisdiction. Who gets to have the jurisdiction in high seas? So, clearly it is the flag state that alone may exercise the jurisdiction on high seas, and Article 91 of the convention says that there must be genuine connection between the flag of the state and seas, and this has been done to prevent any kind of fraud or any kind of ways in which the ship owners register the ship in tax havens to prevent tax. So, it is not necessarily that whatever flag is being flown by the ship would be taken as a flag state, but there must be a genuine link between the ship and the flag that is being flown. However, this is a very subjective test because you never know what is a genuine link or not. So, clearly in high seas the jurisdiction is with the flag state, and some of the important articles regarding that is Article 95 and 96, which clearly says that warships on high seas have complete immunity from the jurisdiction of any state other than the flag state. So, if and the immunity of ships used only on government non-commercial service. So, government ships and warships have complete immunity, whereas for other ships there are certain exceptions that we will see. What are the exceptions? So, some of the exceptions to flag state jurisdiction are piracy. If any ship that is sailing the high seas or indulging in acts of piracy or in slave trade or unauthorized broadcasting then the coastal state may or can approach the ship that is being indulging in these practices, and during these times the exclusive flag state jurisdiction will not apply. Of course, warships and the governmental ships will have complete immunity. And the idea is that warships or the governmental ships are not going to involve in all these activities. And there is the right to hot pursuit. What is hot pursuit means? A ship indulging in any activities within the territorial waters of the coastal state or during the contiguous zone or in the internal waters, and it cannot escape into the high seas to try and absolve them of criminal liability. So, these are the exceptions. So, some of the exceptions to high seas are right of visit. So, we have to see Article 109 and 110 of 1982 Convention. So, if you look at Article 109, it clearly says all state shall cooperate in the suppression of unauthorized broadcasting. So you cannot broadcast unauthorized things from the high seas. Then any person engaged in unauthorized broadcasting may be prosecuted before the court of the flagship of the state of registry of the installation, the state of which the person is national, the state where transmissions can be received, and the states where authorized radio communications suffering interference. And Article 910 gives right of visit. So if you look at this, except where acts of interference derive powers conferred by treaty, a warship which encounters on the high seas a foreign ship other than the ship entitled to complete immunity in accordance with Article 95-96 is not justified in boarding it unless there is reasonable ground for suspecting that the ship is engaged in piracy, the ship is engaged in slave trade, the ship is engaged in unauthorized broadcasting, the ship is without nationality, or is flying a foreign flag, or refusing to show its flag. So clearly these are the exceptions for exclusive jurisdiction of the flag state. So there are right to visit with regard to flag state, and some of the things that are we saw with regard to exceptions to the jurisdictions. And the other restrictions include Article 99, which is of slave trade and unauthorized broadcasting, and there is hot pursuit. I told you, you cannot do a mistake within the territorial waters or the waters of the internal waters of a coastal state and escape into the high seas, in which case the coastal state has its own right to pursue the ship which is escaping into the high seas. And another important thing is about fishing. So Article 194 of the convention talks about the fishing, dumping and oil pollution in the high seas. So clearly Article 194 talks about the pollution aspects of high seas. So we'll just simply read Article 194 to understand just a customary understanding of what it is preventing, what are the pollutions that is being mentioned, and how the convention is taking care of the pollution aspects. In fact, the convention has elaborate sections on preventing marine pollution. So you cannot use, just because high seas is for everyone, it cannot be left unregulated. So here, measures to prevent and reduce control pollution of the marine environment. So states shall take individually, jointly as appropriate measures to protect high seas and from the pollution, from the pollution. So no state can indulge in the activities of pollution. Next, again, one of the important concepts of exclusive economic zone and the high seas is that in exclusive economic zone, a state which calls it the exclusive economic zone has a complete right to do fishing, whereas in high seas fishing is free for all. So there might be some particular fishing stock which might straddle between the exclusive economic zone and the high seas, in which case both the coastal state and the other state which is involved in fishing in high seas must come to a proper conclusion so that they indulge in sustainable fishing and unnecessarily not complicate the matters. So with this, I would like to conclude the topic on high seas. Hopefully it will be helpful for your international class preparation or international test. In case if you have any doubts about this class, do ask me in my comment box. Please like and share this video among your friends whom it will be helpful, and consider subscribing to my channel. Thank you.